And thank you so much for joining us. Today we're going to be talking about the Radburn bill, mandatory changes to the election and voting procedures in New Jersey community associations. Thank you all so much for joining with us. We're very excited to be able to present this new legislation. Only a little more than a month ago, Governor Christie signed the legislation to enhance owner participation in community association elections. We want to give a big thank you to CAI Legislative Action Committee. The committee worked hand in hand with Senator Gordon, the primary sponsor of this bill, to ensure that the final version of the law would not place any significant burden on associations, as well as take into account the concerns of community associations. This was almost a year-long effort. So again, thank you to the LAC committee on behalf of all of their efforts. Our speakers today are three well-known experts from Hill Wallack. I'm sure most of them, the three are well known to all of you, but I'm just going to quickly introduce them and give you a little bit information. So our first, Ron Pearl, he's the partner in charge of Hill Wallack's Community Association practice in Princeton. He's a member of the firm's management committee as well. Ron concentrates his practice in the areas of community association law, construction law, transactional real estate, eminent domain, and tax appeals. He is also a mediator for construction, real estate, and community association disputes. He represents condominium associations, homeowner associations, cooperatives, and real estate developers. Ron is nationally recognized for his work in the field of community association law. During his term as national president of CAI, he pursued a theme of building community and has advocated a fresh look at the role of community associations. He has been extensively involved in developer transition and construction defect litigation over the past 30 years. Carolyn Record is a partner with Morristown, New Jersey office of Hill Wallack, and she's a member of the Community Association and Real Estate Practice Group. Carolyn concentrates her practice in the area of community association law and residential real estate. Her practice also includes estate planning and administration, special needs trusts, guardianship applications, foreclosure, and other real estate-related work. Previously, Carolyn was heavily involved in all aspects of construction defect litigation and was a representative of the steering committee for community associations in the FRT plywood consolidated litigation in the early 1990s. Carolyn's also a member of the CAA LAC committee. Jonathan Katz is our third speaker today, also a partner with Hill Wallack, and he's located in Princeton. John concentrates his practice in the areas of community association law and litigation, and he represents condominium and homeowner associations throughout New Jersey and eastern Pennsylvania. John currently serves on the board of directors of the Pennsylvania-Delaware Valley chapter of CAI. He previously served as the chair of CAI New Jersey's editorial committee, CAI Pennsylvania-Delaware Valley Communications and Content Committee, and also the New Jersey Regional Council. John is also the editor of Hill Wallack's Condominium HOA Law blog. So thank you very much for the three of you speaking today, and clearly well qualified to speak on the topic for today. So a few housekeeping rules before we get started. Okay. First of all, to ask any questions, please use the questions pane in the GoToWebinar dashboard on your screen. We will try to answer as many questions as possible. We will be holding the questions till the end, just because it's possible that one of the speakers will cover that question later on, and we are also cognizant of the time. We will be polling our audience throughout the webinar. Please make sure you answer all the polling questions to receive your continuing education credits. If you're a property manager and receiving credits from CAM, you do need to make sure that you answer all of the polling questions. This webinar is being recorded and will be uploaded on our website at www.wgcpas.com. So we're going to get started. Our first polling question is, just so we have an idea of who's listening and who our audience is, so that helps us in some of our discussion. Who do we have in the audience today? A board, or please answer and indicate if you're a board member, a property manager, an attorney, or an other individual. Okay. So primarily, we have managers, about over half are property managers, about 20% board members, about 20% attorneys, and a little bit of others. So hopefully everybody's going to find this beneficial and interesting. Our speakers are well versed in it, and so we're just going to start and turn it right over to Carolyn Record to begin.
Good afternoon, everyone. Before we begin, we'd like to remind everyone that this webinar and the materials we are presenting are not intended to constitute legal advice, nor are they intended as a source of advertising or solicitation. Your participation in the webinar does not create or constitute an attorney-client relationship with any of the presenters. This program is presented for informational purposes only. You should always obtain specific legal advice from your own attorney before acting upon the information provided. I thought it would be interesting and helpful to start with a brief overview of the Radburn community as well as its governance structure. Radburn is one of the oldest planned real estate developments in the United States. It's located in Fair Lawn, New Jersey, and was established almost 90 years ago in 1929. Radburn was designed as a town for the motor age, and it was ahead of its time in utilizing certain superblock configurations, including cul-de-sacs, and not the traditional gridiron street pattern, in order to maintain a separation of pedestrians and automobiles within the community. The community consists of approximately 149 acres, which includes about 650 diverse styles of homes, in which about 3,100 people reside. The association also contains extensive recreational areas, including a 23-acre park network, 2 swimming pools, 4 tennis courts, 4 baseball fields, 5 outdoor basketball courts, an archery plaza, and a community center. Also included in the community is a shopping plaza, an elementary school, and other components which the founders intended to result in the community being self-sufficient. The community is governed by the Radburn Association, which has the standard common responsibilities of determining the amount of the charges, collecting these charges, and dispersing the monies received in the purpose of maintaining services, the common areas, and of course, is charged with interpreting and implying the Declaration of Restrictions for the community. Radburn is governed by a 9-member Board of Trustees, which is elected by the membership. The interesting fact here, however, is that not every owner in Radburn is considered to be a member. Membership in the association was limited to current and former trustees, which totaled approximately 40 out of the 3,100 residents. These members are the only persons who could vote for the trustees or be eligible to run for the board. And the only way to become a member was to serve as a trustee. And the only way to be able to run for the board was to be nominated by the sitting trustees. Radburn, however, also had a citizens association whose president was automatically given one of the 9 seats on the Board of Trustees. The Citizens Association was created to give the non-member residents a forum for voicing their opinions and addressing the concerns. Because this was such a unique structure, you can imagine that the over 3,000 non-members were not happy about this form of governance. And in 2004, the issue apparently came to a head when the board sold a portion of the parkland for construction of a condominium complex. In late 2006, a group of residents filed a lawsuit and challenged the board's system of governance. The appellate division in 2010 ultimately found in favor of the association and upheld the election membership procedure. However, they did indicate that the board was required to open its meetings to all owners and disclose certain financial documents. The outcome of this lawsuit was not favorable and caused an uproar within the community. So several of the residents contacted State Senator Robert Gordon, who at one time resided in the community. And Senator Gordon subsequently consulted with the CAI Legislative Action Committee with regard to a piece of legislation that could address some of these election concerns. This piece of legislation was introduced about a year ago in September of 2016 with the intent to make Radburn's election voting process more inclusive and transparent. This piece of legislation was not the first attempt to create a standard form of election process in the state of New Jersey. Election reform legislation has been introduced over the years, and the CAI Legislative Action Committee has always had these types of legislation on its radar. Legislation was introduced in May of 2011, January of 2012, and January of 2014, with nothing occurring. However, Senator Gordon's legislation, which was introduced in September of 2016, had 7 primary sponsors and 12 co-sponsors in the Senate, and 4 primary sponsors and 2 co-sponsors in the Assembly. After about 2 months, the legislation was approved by the Senate by a vote of 35-0 with amendments and then referred to the Assembly. After 3 sets of amendments, some technical, some substantive, the legislation was then approved by the Assembly by a vote of 74-0 in May of 2017. It then had to be referred back to the Senate because it was different from the version previously approved by the Senate, but 3 days later it was approved by the Senate by a vote of 39-0 and ultimately signed by our governor on July 13th of 2017. I'll now turn the program over to Ron Pearl, who will talk in more detail about the election process.
Good afternoon. Hill Wallack is pleased to present this webinar in conjunction with Wilkin Guttenplan, and we thank them for their participation. The next 2 segments of the presentation, mine and Jonathan's, are intended to highlight the specific requirements of the legislation, hopefully in a way that will allow you to feel more comfortable working with it. For community managers, our hope is that you will be able to discuss it with your boards and use it as you prepare for elections this fall and thereafter. As Caroline has said, this program is for general information about the new law, and we encourage you to seek the advice of counsel as you implement this for the first time. This legislation is part of the Planned Real Estate Development Full Disclosure Act, which some call PRED, others PREDFDA, and it applies irrespective of when your association was established. One of the substantive changes, and really the main purpose of this law, has to do with eligibility to serve on an association's governing board. The Radburn Association, as Caroline illustrated, had severely limited the ability of most homeowners to serve on the governing board. Oh, I'm sorry. We now have another polling question.
Okay. What's the biggest complaint you receive about your election process? Please select one. Insufficient lack of notice, lack of candidates, good standing issues, or proxy ballot issues. Okay, so looks like we have the majority of people that have voted, and it's pretty clear. The biggest issue people have is lack of candidates, and the second largest issue is proxy and ballot issues. And certainly this is the proxy and ballot issues is addressed in this legislation. Okay, Ron, if you'd like to continue on, thank you.
All right, so as I said, the law was intended to address the limited ability of most homeowners in Radburn to serve on the governing board, and it ultimately led to litigation and this legislative change. The result is that any member in good standing may run for and serve on the governing board of a community association. Members in good standing may nominate themselves or another person. They may vote and serve on the governing board. The definition of good standing is contained in the law as well and goes beyond what you might normally expect. The expected part of the definition is the requirement that a member be current in paying his or her common expenses, late fees, interest, legal fees, or other charges that are lawfully assessed. And that is directly from the legislation, other charges that are lawfully assessed. Note that being in compliance with the rules is not part of the good standing definition regarding nominations and electing. However, other charges that are lawfully assessed could include fines or capital contributions. Further, what you might not expect is that a member is in good standing if he or she is in full compliance with a settlement agreement to pay past due assessments or other charges, or if the member has disputed the charges and that dispute is not resolved. An unresolved dispute means that there is a pending ADR or pending litigation concerning the disputed charges. In my opinion, requesting ADR in accordance with an association's valid ADR procedure creates or begins a pending ADR. In other words, the ADR procedure need not be scheduled, a hearing need not be scheduled, it just needs to be validly requested. The purpose behind this provision of the law is to protect owners who are subjected to assessments or other charges which the member feels are wrongfully imposed. While the issue is being resolved, the owner retains the rights of membership. This seems to be a fair balancing of interests, since the effect on the individual member of the loss of a vote and/or eligibility to run for a board seat is probably greater than the effect on the association. In any event, the current status of the law, via this new legislation, is that the member retains good standing while those issues are being resolved. Another issue that arises in associations frequently is the question of whether members of the same household, for example, a wife and a husband, may both serve on the board. The proponents of allowing this say that apathy makes it difficult to fill board seats, and our poll today confirms that. And it's sometimes necessary to have more than one representative from a single home in order to fill them. Others argue that each co-owner is a separate person who's entitled to serve on the board. On the other side of the argument, they say that it makes one family or one household too powerful because the spouses or other co-owners will have the same views and vote together on important issues. The legislation permits your bylaws to restrict the service on the board by more than one member of a given household. This deviates from the general rule that all members in good standing are entitled to run for the board, but it must be in your bylaws. In other words, the prohibition against more than one board member from a single unit must be in the bylaws. But if it is enforceable. Next, terms of office for board members. The legislature had a concern with long terms of office and the frequency, or lack of frequency, of board elections. It therefore added a new section, N.J.S.A. 45:22A-45.2, dealing with board elections. That section mandates that elections must be conducted in accordance with the governing documents unless they conflict with the provisions of the new law. In other words, you can't ignore governing documents, meeting requirements, notice requirements, or the like. But there are certain provisions of the new law which now take precedence over certain bylaw provisions. If the documents do not set a specific interval between elections, they must be held at least every 2 years. Now, I haven't seen too many documents that don't specify the interval between elections, but if your documents are silent on the subject, they must be held at least every 2 years. If an association hasn't been holding elections as required by the governing documents, it must hold an election within 90 days of receipt of a petition signed by at least 25% of the members in good standing. The 90 days starts when the petition is received by any current board member, not just the secretary, not just the president. It can be given to any sitting board member. So in an association where elections are not being held in accordance with the governing documents, there is a petition process, and 25% is the number of members in good standing that need to request that an election be held. If the petition is ignored, any member or group of members may petition a court for authority to act temporarily on behalf of the association and conduct an election within 90 days of the court order. So this empowers the Superior Court of New Jersey to receive and deal with an application by as few as one member or a group of members of the association. It also means that the member who petitions the court or the group of members will take the place of the board for purposes of conducting the election. Yes, that includes collecting and counting ballots. The law uses the term organize and hold an election, and in our opinion, it includes everything from the notices through certifying the count. And this will only be under court order, but that court order will give these extensive powers to the petitioning member or group of members. This new section on election differentiates between associations having fewer than 50 units and those having 50 or more units. For the smaller associations, there are no specific time frames or detailed requirements. The requirement is somewhat general, but it does include certain specific requirements for those smaller associations. The smaller associations must ensure a system where there is, first, notice, the ability to nominate, and the ability to vote for any member in good standing. Next, transparent requirements and clear qualifications to run for the board. Also, ready access to information on how and when to vote. And also a process for the counting of ballots and verification of eligibility to vote. So while there are not specific time frames involved, the law mandates that these basic principles be followed by the smaller associations, and it also mandates that all steps of this system, this election system, must be conducted in a non-fraudulent manner. Now, the requirements for larger associations, which the law defines as those with over 50 units, they're more specific. First, they deal with terms of office, which are limited to 4 years, although there are no limits on the number of terms that a person may serve. Also, a board member may serve until his or her successor is duly qualified and elected. And I've seen that in the majority of documents with which we deal, that if for some reason you lack a quorum, that board member may serve until the successor takes office. If your bylaws do not specify an interval between election, meaning the frequency of elections, an election must be conducted every 2 years. If your documents say that elections are to be held every year, then an election must be held every year. In other words, if they do provide for annual elections or elections every 2 years or even elections every 3 years, your documents should be followed. But if they do not specify an interval, then the default provision under the law is 2 years. But I'll also point out that since the maximum term of office for a trustee is 4 years, if your documents provide a longer interval than 4 years, they will not be good, and you will have to revert to a 4-year requirement at the most. But there aren't too many documents that specify that long of an interval between elections. All members in good standing have the right to nominate themselves or other members in good standing. A notice to this effect, which is essentially a call for candidates, must be sent to all members at least 30 days prior to the mailing of the official notice of meeting. This is a new requirement under the law, a call for candidates, and a notice that each member in good standing has the right to nominate or be nominated. The association must allow at least 14 days for members to respond to the call for candidates. It can allow more, but it has to allow at least 14 days for the members to respond to this call. We'll discuss the overall timing in a minute. Next, the notice of the meeting. The notice of the election meeting must be sent at least 14 days, but not more than 60 days prior to the meeting. Minimum of 14, but not more than 60. This will be consistent with most existing governing documents that I've seen. I've rarely seen documents that don't already have notice requirements that are pretty much within this range. As far as methods of notification, it must be accomplished by either personal delivery, mail, or by electronic means, although electronic communications may only be used if permitted by the governing documents or a member agrees to electronic notification in writing. In order to implement this provision, I would suggest distributing forms to each owner and asking them to consent to electronic notice of meetings and electronic voting. To me, one of the most beneficial and exciting parts of this legislation is the adoption of electronic communication and voting. For years, publicly traded companies have used electronic notice and voting quite successfully, saving both dollars and time and gaining efficiency and participation. There are companies that conduct voting by electronic means, and if done properly, they provide for verification and security. I've been amending documents for clients over the past few years to permit electronic notice and voting when the law eventually would permit it. And now that this law has passed, those provisions will be activated, and those associations will immediately be able to employ the electronic alternative. And by the way, all my amendments contain an opt-out provision for individuals who cannot or choose not to use the electronic process. I would encourage all associations to explore this possibility and pursue amendments and/or member consent, as it represents an important advance in our industry. The next slide shows a sample timeline. It represents a relatively short timeline using the minimum requirements of the law, but it is intended to illustrate that you will really need to think ahead and begin the process of scheduling elections perhaps earlier than you have in the past. Here, we've worked back from a November 14th election. If you look at the calendar, you will see that some of these dates fall on a weekend, so remember, these are for illustration purposes only. But what this does illustrate is that you pretty much need to get started in early September for a mid-November meeting. In our example, the call for nominations goes out on September 17th. You must send that out. In other words, the call for nominations, as I said, 30 days prior to the mailing of the election meeting notice. Call for nominations must be 30 days prior to the mailing of the meeting notice. And then allowing 14 days for nominations to be made brings us to September 30th. Now remember, you can allow more than 14 days if that works for you, but that would then extend the time for response, but you still must send out the call for nominations 30 days prior to the mailing of the election meeting notice. In the illustration, the notice of meeting goes out October 16th, which is the required 30 days after the call for nominations. The notice must include proxies if they're authorized and absentee ballots. Jonathan will talk more about this in a couple of minutes, but in our illustration, we've chosen to give 30 days notice of the meeting because in our experience, that's a common time period, so the meeting will be November 14th. But here's the tricky point. The law says that even if you set a deadline, nominations must be accepted up until the day before the mailing of notice of the meeting. Nominations must be accepted up until the day before the mailing of the notice of meeting. And I know some of you managers are scratching your head right now. The mailing, by the way, cannot occur until 1 day after the nominating period ends.
Ron, can I ask you just a question that's come in on the days? When we talk about the days, are we talking business days or calendar days?
The law doesn't specify. I believe
Okay.
it means the calendar days.
Calendar days,
Yes.
okay.
It doesn't specify business days, so it would be calendar days
Calendar
by
days.
default. Yes.
Okay, thank
And
you.
our example uses calendar days as well.
Okay, thanks.
So back to my tricky point. We have a large association. One of our clients has more than 1,500 homes. Let's say they have all the notices printed and stuffed in envelopes with postage on them the day before the mailing, and then the nomination comes in. Do you have to throw away all those ballots and envelopes? My personal opinion is that if you're in a larger association, you set a deadline consistent with the law, and in the normal course have the ballots printed, and are in the process of mailing and a late nomination comes in, you would certainly have an argument that you're in compliance. But I can't guarantee that because the law says you must accept a nomination, quote, so long as the nomination is made prior to the mailing of ballots or proxies to the association members, end quote. If I have a practice tip here, it is that you should mail at least a few notices and ballots, even in a large association, the same day as the notices, proxies, and absentee ballots are printed. Because once you start the mailing, it's a mailing. Before I pass this off to Jonathan, I want to mention the concept of a voting eligible tenant, the definition of which is on the current slide, as well as certain kinds of associations which contain voting systems that are specifically permitted under this law, even though they don't include direct voting by specific members of the association. First, the tenant issue. You won't run into many governing documents which permit tenants to vote at this time, but this law recognizes the concept and opens the possibility for associations to amend their documents to allow tenants to participate in the governance of associations or for developers to include the concept in new projects. Whether this is good or bad is not part of our discussion today, but just understand the possibility exists. Finally, I want to mention 4 situations specifically permitted by the law in which boards may be elected other than by direct proportional vote of the members. Just want to mention them as we don't have time for a full discussion of each of them. The first is in a mixed-use development. You can have certain board seats reserved for different uses within a mixed-use development. The most common example of a mixed use is commercial and residential combinations where certain seats are assigned to the commercial owners and others to the residential. You may also have other combinations of uses and a board where seats are assigned to each different use is permissible. The second situation involves affordable housing, where affordable units make up a minority of the community, but certain board seats are reserved for these units to assure representation of affordable unit owners. This is permissible as well. Also, voting by section is permitted where a development is divided geographically and each section is permitted to nominate candidates for and vote for certain seats on the board. So you may have associations where there are different sections that vote within their section and nominate candidates within their section for representatives to the board. The one requirement in all these situations, except for affordable housing, is that the voting weight must be approximately proportional to the number, value, or size of units. So it can't be random and it can't be arbitrary. It has to be proportional to either the number, the value, or size of the units. With that, I will turn it over to Jonathan Katz. Thank you.
Okay. So just before Jonathan gets going, we do have one, probably our last polling question. So thank you, Ron, before we start with the question. Okay. So prior to this legislation, what was the voting requirement to adopt an amendment to your bylaws? Simple majority, 2/3, greater than 2/3, no amendment provision, or have no idea. So everybody is voting. And okay, looks like most people have their answers in, and pretty much about 60%, 2/3 are required. About 20% are a simple majority, and then about 15% is greater than 2/3, and the rest of you are quite short. So that kind of sums up where people stand on what they need in terms of adopting an amendment. Okay, Jonathan?
Thank you.
Turn it over to you.
Thank you. So before we get into the new requirements regarding proxies and absentee ballots, let's start with a brief discussion of what proxies are and what absentee ballots are. A proxy is not a method of voting. Rather, a proxy is a grant of authority by an owner, member, or voter to a representative or agent to vote on that member's behalf. A proxy may be used as allowable by law and pursuant to the association's governing document. An absentee ballot, on the other hand, sometimes also called a mail ballot, is a written ballot that may be cast by a voter without attending the meeting and may be mailed or otherwise transmitted to the association. You may have also heard the term directed proxy or proxy ballot, which is essentially a proxy that instructs the proxy holder how to vote on a specific question or who to vote for in an election. The difference between what we'll call a straight proxy and a directed proxy or a proxy ballot is that the straight proxy does not instruct the holder of the proxy how to vote, but rather gives that person the authority to vote on another's behalf based on how the holder of the proxy wants to vote. The proxy system really comes from the corporate world, but has worked its way into the association governance. Most governing documents that you will see will allow voting either in person or by proxy, so it is something that most associations are required to offer pursuant to their specific documents. So with that knowledge, let's look at the provisions of the new legislation pertaining to proxies and absentee ballots. The first is, if your governing documents allow for proxy voting, you must now also offer absentee ballots. Some documents will only allow for voting in person or by proxy, like I previously said. So in those cases, the option to vote by absentee ballot must now be made available to those community associations. As mentioned previously, proxies are an authorization for someone to vote on the member's behalf. Directed proxies or proxy ballots appoint a representative to vote in a specific manner, and absentee ballots are the direct vote submitted in lieu of attendance at the meeting. Also, proxies must contain prominent notice that the use of the proxy is voluntary and that it may be revoked at any time before the proxy holder casts a vote. So generally, proxies may be revoked, while absentee ballots may not be revoked. Let's talk about voting procedures. The new law requires that all election ballots are required to list the names of all candidates nominated in alphabetical order by last name. We have in the past seen some elections where the board members were listed first or where there was some other method to determine placement on the ballot. That is now prohibited by the new law. Interestingly, we have also seen where some associations will list current board members as incumbents or current board members on the ballot. There's no specific prohibition on doing that in the new law, and it would be allowable unless your specific governing documents or election rules prohibit it. Also, as Ron had mentioned, associations may now utilize electronic voting when authorized by the documents and when the association members consent to casting a vote electronically. It bears repeating that electronic voting is a ballot that is cast online or through the other electronic means without attending the meeting, delivered directly to the association through a website, email, or other secure program prior to the meeting. It is, in essence, an absentee ballot or mail ballot that is transmitted electronically. This is one of the more overlooked provisions of this legislation, and now that it provides statutory authority for New Jersey community associations to be able to vote electronically. While this issue may not have come up previously in many associations, many states' nonprofit corporate statutes or association enabling statutes do not specifically address and/or authorize the option of electronic voting. In addition, most corporate statutes provide that elections or other action can be taken only in in-person meetings of the members or if no meeting is held by unanimous consent. For example, New Jersey's Nonprofit Corporations Act provides that only that election of trustees may be conducted by mail, and the Act authorizes decisions to be made in lieu of an in-person meeting only if all the members entitled to vote therefore consent onto writing. There is no mention of voting by electronic means. Again, this new legislation now specifically authorizes a community association to utilize electronic voting. Please note, however, that as Ron mentioned, this electronic voting does not mean that the association or the management company can just accept ballots via email. Rather, electronic voting means that ballots are cast online or through another electronic means without attending the meeting and delivered directly to the association through a website or other secure service or program prior to the meeting. Also, the association cannot make electronic voting the sole means to vote. It still has to offer other methods of voting pursuant to its documents, and again, that goes back to in-person or by proxy. Finally, on this point, we would recommend strongly that you talk to your association's council to adopt an amendment if you're considering allowing electronic voting within your association. So we had already done this polling question, and as Carol said, a lot of you have either 2/3 or simple majority, so we're just going to skip by this for now. And then we're going to actually talk about what it takes to amend your documents. So this section, probably more than other sections, has created some confusion and a lot of debate, including debate within our office. So hang tight with me. I'm going to try to explain this as clear as possible. If your bylaws require a vote of 2/3 or less to amend, the new legislation does not change that provision in your documents. However, if your bylaws have no amendment provision, or if the amendment provision requires more than 2/3 to amend, that provision is no longer valid, and the law substitutes a new requirement. And that new requirement is the bylaws may now be adopted by an affirmative vote of the majority of the total authorized votes in the association. And I'll say that again so we all understand it. If your bylaws currently require over a 2/3 vote to amend, or if there is no way to amend your bylaws, that is no longer valid. Instead, that provision is now replaced, and the bylaws in those associations may now be amended by a simple majority of the total authorized votes. Total authorized votes, as defined by the legislation, means the total number of units minus any members who are ineligible to vote because they are not in good standing. So essentially, amendments will now be allowable if 51% of those owners in good standing vote in favor of an amendment. The next provision talks about when the board can make amendments to the bylaws without an affirmative vote of the members. And again, this new legislation can be interpreted to allow an association's board to amend the bylaws without a vote of the members when, if necessary to render the bylaws consistent with state, federal, or local law, or if a ballot provided to the members to reject the proposed amendment fails to receive at least 10% of a vote within 30 days. So, if the bylaws are currently in conflict with state law, including this legislation, the board can amend those provisions without putting that question out to the members. Also, there is now this amendment by rejection provision, which is almost a backwards way for the board to be able to amend without an affirmative vote of the owners. In essence, this should make it easier for boards to amend the bylaws for certain non-controversial issues. The reason we say that this new legislation can be interpreted this way is because some attorneys are interpreting this section to only apply when your bylaws currently require over that 2/3 we talked about previously, or if there is no provision to amend. However, we do not read this provision to restrict it only to those associations, and we believe that this will apply to all associations going forward. That being said, because it is somewhat unclear as to how this provision will be interpreted in the future, we strongly recommend you consult with your association's counsel before attempting to amend using one of those provisions. And finally, regarding amendments, again, remember that these changes to the amendment provisions apply only to an association's bylaws. It does not affect how amendments may be done to either your master deed or your declaration. So this was mentioned by both Caroline and Ron. The majority of the provisions in this law are effective immediately as of July 13th, which is when the law was signed into law by the governor. However, there is a grace period for the election notice provisions, which should be effective as of October 1st, 2017. So in terms of upcoming elections, as Ron discussed, you're going to need to start the process earlier, probably between 75 to 90 days earlier. So these new provisions will apply to elections after October 1st. So what does this mean for our association? Again, this legislation amends and supplements the provisions of the Planned Real Estate Development Full Disclosure Act. To the extent that the requirements of this legislation conflict with an association bylaws, these new provisions will trump the requirements of those bylaws. And most importantly, all owners within an association must now be considered members of that association with the ability to fully participate in elections and include the ability to both run and vote for members of the board, so long as they are in good standing. So we're going to be finishing up and starting to take questions in a minute, but I also wanted to remind everybody that all the information we spoke about today is available on Hill Wallack's blog, and that's www.condolawnj.com, or you can follow us on Twitter at NJCondoLaw.
Okay, thank you, everybody. So we have a number of questions that have come in. We're going to go through as many as we can, and if you think of some more questions, feel free to type them in. I'm not sure if we'll get to them, but we'll give it a go. All right, so I'll read the question, and whichever one of the three of you would like to answer, or you think you're best to go with it, we can just do it that way. So does the law define in good standing? Is that open for interpretation, or does the law define that?
I think, yes, the law definitely defines good standing in this context to mean financial good standing. It means payment of your assessments and other charges currently. Some associations I know will consider a member in good standing if, for example, they have an outstanding architectural violation. That is not the intent or the provision of this law. Good standing is current with your financial obligations to the association, or as I mentioned earlier, in the process of contesting one of those financial obligations via ADR or the court system.
Okay. So with respect to the good standing, based on being in the good standing, what date determines eligibility? So if a nominee is eligible, is a nominee eligible if they're behind when the nominations close, but they pay up prior to the day of voting? So at what date is good standing in place?
Well, if the nomination, if they are not in good standing as of the close of nominations, they can't be nominated or nominate. If they then come into good standing, they are probably eligible to vote. If they come into good standing before the election day, the election meeting. Okay.
Another question about good standing, is there anything with those are in violations of restricted covenants or just financial?
Just financial.
Okay. All right. So if a community provides that affordable units have a weighted vote, does the Radburn law now make it an equal vote with the market units?
If they have a weighted vote, the only exception, the affordable housing exception, applies to seats on the board that are reserved for affordable housing members. So the Radburn legislation does not permit disproportionate voting, in my opinion, with regard to the affordable units. It only permits bylaws to contain a provision reserving certain seats to affordable units.
Okay. Have term limits been added?
There are no term limits. There is only a limitation on the length of a term, and it can't exceed 4 years.
Okay. Let's see. So, does the law require a current board member to continue on the board after their term is up if no one ran for their seat?
Well, the law permits it. You can't force somebody to serve on the board. So if that person chooses not to continue until the successor is qualified and elected, that person can resign at any time.
So what if bylaws say 67%?
So again, if your bylaws say 67% or less, this legislation is not going to affect them. It's either where there's no provision to amend your bylaws or where it's over 67%.
Well, I guess the question is 67% considered 2/3? And I would think a reasonable interpretation is that it is.
Okay. All right. Does the law require elections to occur at a meeting and not by mail?
Doesn't require meetings. I don't think it trumps provisions of bylaws which require elections to be held at a meeting. However, it does permit absentee ballots where proxies are permitted.
Okay. Do you think that a directed proxy satisfies the requirement to have an absentee ballot?
So this is a question that we've kind of thrown around a little bit. The law is clear only in terms of that if you offer proxies, and most documents that you will see will make the requirement, will offer proxies. It doesn't specify whether that can be a directed proxy or not. The only thing that this law changes is that if you offer a proxy, you now also are required to, whether it's in your bylaws or not, offer an absentee ballot. And as like I said before, we've talked about this, a directed proxy does probably satisfy that, so long as, again, you're giving the opportunity to vote for a specific, whether it's an election or answer a specific question.
Okay. A couple of questions have come in about master associations. Can you explain the voting in for master association boards and how this would affect master associations?
Well, different associations have different voting requirements for their master. We represent one where all of the members in each of the, I call them sub-associations. You have master and you have sub-associations under the master. They vote directly for all of the members of the master board. If there are, just take a number, if this association has 400 members, all 400 of the members, or those who are in good standing, get to vote for the members of the master board directly. Other associations elect their own sub-association board, and those boards appoint a representative to the master. And that's okay. That's one of the exceptions under the Radburn law.
Do these laws apply to co-ops as well?
Under the PRED, it applies to all forms of ownership.
Okay. All right. So if a board member becomes delinquent during their term, can they be removed, or does this law even address delinquency at that point?
No, my reading is that it doesn't provide that you automatically become disqualified and are removed for office. It doesn't go that far. This deals with the qualifications for nomination, voting, and election to office.
And how's this legislation enforced? Is it through the courts or government oversight, or?
Well, I think there's a mixed bag there. There is a specific provision that I mentioned with regard to enforcement through the court system, where an election should be held and the governing board either doesn't exist or refuses to permit it. It allows a court to enter an order specifically. There are also remedies via the court system under the Nonprofit Corporation Act that have always been available to associations. Whether or not this gets enforced through a regulatory process through the state is unclear to me. I don't see any provision in here dealing with the authority to adopt administrative regulations to carry out the purpose of this. Normally, if, for example, the DCA were to issue regulations, the law itself would have to authorize the DCA to issue enact administrative regulations to carry out the intent and purpose of the act, but I don't see that in here.
Okay. A few questions about absentee ballots and proxies. So, does a directed proxy allow a designated person to vote for an individual, or does it designate who that individual should vote for?
Right. So generally, what I refer to as a straight proxy will just appoint someone to vote on a member's behalf. The directed proxy will be a lot like in the form of an absentee ballot. And in that case, what we're calling a directed proxy will appoint someone to then vote for the direction of that person who's granting the proxy.
So let me just add something here, because this is how I'm going to advise my clients, and since all of you out there are not my clients, I suggest that you check with your own attorney, as we said earlier. But I think, to make things less confusing, that I would distribute a non-directed proxy. Just give the member three options. One, of course, is voting in person, or I guess electronic voting if you have it, consent or in the bylaws. And then I would send a proxy and an absentee ballot so they look different. If you do both a directed proxy and an absentee ballot, it is going to confuse people. In fact, most bylaws do not require that a proxy actually be mailed out, but you know, most people that do that. So I would have a non-directed proxy, which just says I appoint blank, or if nothing is filled in, the secretary of the association to be my representative and vote for me at the meeting. And in addition, I would put an absentee ballot with the candidates' names in alphabetical order, so if they actually want to vote, they can vote. And so they're going to do one of two things if they can't vote in person or electronically. They're going to either send back the non-directed proxy, in which case, fine, the secretary votes, or they're going to send back the absentee ballot, which is fine because then you know how they want to vote, or they're going to send back both, in which case I would use the absentee ballot and forget about the proxy. So I think that solves the problem as a practical matter, for what it's worth. But again, seek legal advice from your own attorney.
Okay. If an association that has a rule but not a law requiring owners to be present at a nominating meeting, are they still permitted to utilize that rule? Or now must the association now allow people to nominate or self-nominate by mail? So if they have this rule, can they keep with it, or?
This doesn't deal with, let me put it another way. What the law requires is that everybody is able to nominate, every member in good standing is able to nominate and run and vote. So if your nominating process, excuse me, is that if your bylaws say that you have to come to a meeting to declare your candidacy, this law doesn't necessarily overturn that provision, as long as you're allowing every member in good standing to do that. However, I can see a potential challenge on the basis that requiring somebody to appear in person, let's say, for example, they're a non-resident owner, that it discriminates against them, especially if they live out of state, or if you have the nominating process during a time when many in an age-restricted community are living out of state for the cold weather. I could see that it would be an impediment, an unjustified and arbitrary impediment to permitting people to nominate themselves or others. So I think there are problems with it, but there's nothing that directly deals with that in this legislation. But there are problems with it.
People, there's a couple questions about the two owners of a unit. So we just clarified, does the legislation prohibit it or allow it?
The legislation does not prohibit two owners from the same unit to serve on the board. What the legislation permits is a bylaw provision that requires only one board member from a given unit. All right. So otherwise, you know, the law says generally every member in good standing is eligible to run. Each of the co-owners who is financially current with the association is a member in good standing. So this clarifies that if you have a bylaw provision that says only one representative can serve on the board from each home, that doesn't violate the general provision in the law saying that each of the co-owners is a member in good standing.
Okay. I think we have time just for one last question. So if your bylaws do not provide a provision for e-voting, do you need an amendment? And do homeowners have to complete an opt-out notice or an opt-in notice? So in other words, can you implement e-voting for everyone unless they specifically opt out, or the other way around?
All right. So I hope I didn't confuse anybody.
You got 1 minute there.
1 minute. Okay. Two options under the law. You can amend your bylaws to allow for it, or you can get the consent of individual owners to use the electronic process. If you're going to do an amendment, my amendments always have an opt-out process. Some people simply can't do it, especially in age-restricted communities, although it's not limited to that. There are some people that are not computer literate, so they would have problems voting that way. But the two choices are the member consents, or you do a bylaw amendment dealing with it. Okay.
So you spoke so quickly, I can fit one last one in really fast. This is if a person owns 2 units, is in arrears on one unit, but in good standing on the other, which takes over? Are you in good standing or not?
For the first unit, yeah.
You could be in good standing for one unit and not another.
Yeah.
Yes.
So
if you're current in all of your obligations with regard to one unit, you get the vote and you can run with regard to that unit. If you're not, that's my interpretation of it. That if there's another unit that's not in good standing, then with regard to that unit, you don't get to vote or run.
Right. So thank you very much. This is Carol Karansky again, and I want to thank you all for participating and listening. Unfortunately, we were not able to get to all the questions, but hopefully we got to a bulk of them. We will be sending an email out, and In that email, we'll have all the contact information, phone numbers, website, so that if you have any questions, you could reach out. Again, as Ron has said, if you have specific questions, then certainly contact your attorney and ask and follow up. But this will be uploaded on our website, Wilkin Guttenplan's website, wgcpas.com, so you'll be able to watch the webinar again if you'd like to. And if you have any questions, please reach out to us, and that contact information will be in the email that you will be receiving shortly. Thank you very much for listening, and thank you very much to Hill Wallack for putting on this very informative lunchtime webinar. Thank you.